Good afternoon, everyone. I, CS Yogesha, on behalf of Institute of Company Secretaries of India, extend a very warm welcome to our respected speaker and participants who have joined us today for this enlightening session on company incorporation and related matters under the umbrella of EEE 5.0 Master Knowledge Series. Company incorporation marked the foundational step in the life of any business entity, setting the legal and structural framework within which it will operate, grow, and comply with the regulatory requirement. The process involves a careful blend of legal compliances, documentation, procedural accuracy, and strategic planning. For the company secretaries, incorporation is not merely a registration exercise, but a critical professional responsibilities that lays the foundation for company's legal identity, governance framework, and long-term compliance culture. This webinar seeks to provide participants with an in-depth understanding of the incorporation process, the legal provisions governing it, and the recent reforms introduced by the Ministry of Corporate Affairs to promote ease of doing business. Now, with this small brief on the today's topic, I would like to welcome our eminent speaker, CS Deepak Sharma, who brings with himself immense experience in this sector. Now, I would like to read his brief profile before our members and the participants. He is fellow member of the Institute of Company Secretaries of India and a practicing company secretary with more than 2 decades of experience providing advisory services to corporate and providing legal financial opinions. He has been providing consultancy services to both Indian and multinational companies, LLP, partnership firm, trusts, societies, NGOs. He has been a speaker on many subjects relating to corporate laws, legal and secretarial audit, doing business in India, IBC, listing and compliances. He also deals in the international joint venture agreement due diligence process. He has been the guest faculty in many management colleges, Controller and Auditor General of India, CCS University. We are privileged to have such an eminent speaker to deliberate on the today's topic. And I'm confident that today's deliberation will be enrich our understanding and equip us with the knowledge. Once again, I welcome you all and thank you for taking time to join us today. Let's engage, learn, and grow together. Over to you, sir.
Thank you so much, Yogesh, for the introduction. And thank you so much, ICSI, in providing this great opportunity, whereas we professional can interact on a platform and a single platform on a subject which is very critical and relevant for the profession. Post V3 phase, when we all are facing a lot of challenges, lot of new things which are coming up, technically speaking, and a combination of young and senior professionals have come together to just deliberate on these critical issues. I think makes sense in today's professional sphere. ICSI, as always, has been the torch bearer for all of us as a member, and it's our duty, in fact, to spread the knowledge and share the knowledge wherever it is necessary, and especially for those who have just joined the profession. In fact, the young fraternity.
Yeah.
The Triple E series, which is really meticulously designed, has provided us an opportunity to take this lecture critically and to raise questions, to deliberate, to discuss those things which are in a normal professional life, all of us are facing. Though this is technology oriented, but yes, the subject which has been the point of line of discussion for today's topic is really very basic, fundamental, but at the same time is really important for the stakeholder and the intention and the objectivity of the Ministry of Corporate Affairs especially, and together with, if you run through Ministry of Home Affairs, what is the objective they are just taking care of. I think all of us will appreciate the way Ministry is doing very hard work in technological advancement and deployment of some AI techniques actually in the MCA 21 system. I think the time I have passed, it's almost 18 years now. 18 years means a child who becomes major. So it was 2006 when MCA 21 got birth. It was June 2006. If many of us who are joining with me and belongs to that era, so 2003, if you rightly recall, it was a time when we started talking about technological advancement and online procedural aspects with regard to the day-to-day affairs of respective registrar of companies offices, regional director offices, and other minister of corporate affairs offices. So that day come, and June 2006 was the time when all physical transformation was done, and it was online process. In 2025, it's now MC21 is 18 years of old. So now we are mature, we are adult as a MCA 21, and we have witnessed a journey, whereas the physical transformation to online transformation has been tremendous as a professional, and we have seen a lot of changes within the MC21 system. And now we are at a position where V3 segment has been recently introduced and makes sense to discuss this kind of topic. Now the topic comes back to the topic, the incorporation of companies, some critical aspects. So yes, we as a professional give our services to the professional. We as an in-house company secretary give support system to our corporate, taking care of every aspect, every modality, every objectivity, whatever is in the minds of the promoter, future promoters, future directors, or founders of a particular corporate. Whenever a stakeholder or a client comes to us, it's first question. And by the way, he or she, they are informed a stakeholder, where they come across and they just simply ask, let's incorporate a company. What is that? Let's understand it. Technically speaking, whenever any stakeholder or technically any client is coming to your office, he literally ask you, and this is nothing but a study says that at least 93% of the time when client asks about some structure, a corporate structure, he or she simply asks for a company sort of a structure. It means he or she or the promoter is already informed that what structure will be suited to him or her, taking care of the future strategies, the business plans, and some sort of a issues which they will be just taking care of, maybe in the physical form or maybe in an online form, maybe in a sort of a manufacturing as a trading within the service circle. So, as a professional, it's our duty now. What is the right combination of structure, the corporate structure, whether it would be a company, a LLP, or a partnership firm? What sort of company it should be actually? So, those all I think questions I would try to address today, apart from the technicalities which we are facing under the V3 domain nowadays under MC21 system. I will also touch upon some of the technical points which Ministry of Home Affairs is taking care of for the countries which are sharing land borders with India. And at the same time, I will also touch upon some of the great opportunity for the profession as a company secretary as far as Gift City in Ahmedabad is concerned actually. So I think let's move to our PPT presentation, Yogesh. I'm sharing here my PPT, and yeah, is it visible, Yogesh?
No, sir, it is not visible right now.
Just a minute. Now it is visible. Yogesh, can you
No,
confirm this is visible?
no, sir, it is not visible till now.
Just just a minute. I'm taking care of.
No issues.
I think some issues there.
There may be some technical issues, sir.
No, no, I'm just trying. Is it visible now?
Now it is visible, sir.
Perfect. So, as a part of agenda, let's discuss about you know. Uh, let me just So, as a part of agenda, uh, what is the current landscape, right? And what MCA has updates, what are the data insights which is required to be prepared and final under the V3 porters realities. What are the spice plus ecosystem which has to be deconstructed or reconstructed in a way that it decodes every requirement under the Companies Act 2013 and rules made there under. What are the gatekeepers of identity? How to just obtain those DIN and DSC advanced aspects of the management, which should be related to the documentation part as far as every structure of the company is concerned. What is the national security and FDI related aspects which need to be taken care of under the era of Ministry of Home Affairs approval methodology, and what are the land boarding nations, for which I think the stakeholder and as a professional we should be just ready to take it, and definitely the impactful case laws shaping our practice. Yogesh, please confirm whether a part two strategy execution specialized advisory is just visible on the portal on
Yes,
the
sir, it is
screen.
visible. Visible,
Perfect.
sir.
Perfectly. Now I'm just taking care of this. The corporate identity which need to be understood as a advanced strategy. Why? Because you take a lot of time and efforts in understanding the client's requirement, that what sort of corporate identity they want to shortlist and they want to incorporate. So whatever is necessary under the provisions of the Companies Act, and more or less if you go through section 4, 5, 6, and 7, so you will definitely come to know the incorporation processes under the V3 era. What is the deep dive when we take part A and part B in isolation, and when we take part A and part B of the Spice Plus together? How integrated web has made the life of professional and stakeholder easy when they proposed and they introduced Agile Pro S, and it has to be unpacked. Why? Because it is beyond the acronym. Why? Because a lot of services including EPFI, EPFO, ESI, GST, Bank Open, and other more than 10 services have been covered under this integrated web system. What is the professional best practice? What are the do and don'ts we should definitely keep in mind while managing and strategizing, in fact, rather, to advise our client. Then at last, definitely we'll touch upon some of the entity blueprints, and in depth what are the checklist for all major type of corporate structure actually. Yogesh, I think slide had changed to current landscape. I'm just confirming.
No, sir, it is currently on the same slide, which is on the agenda part two, strategy execution. And yes, and now it is changing, sir. Now it is on
Right.
the fourth slide, sir, which is the current landscape.
Absolutely, absolutely. Now I will take this action. Now, dear friends, we have to now, issue which has to be discussed over here as a key updates from MCA newsletter recently. Why? Because every one of us has the access to the MCA 21 system, and we can have the access to the newsletter, which is a fantastic piece of document which is monthly published by the Ministry of Corporate Affairs. And if you take recent confirmations from the ministry, it has introduced some of the basic forms under V3 portal. One of those forms is CRF. So to start with, when we take incorporation related documents, a lot of things happens. Maybe inadvertently, maybe some sort of a punching mistake at the time of incorporation, that cannot be corrected under the CRFF mode actually. Why? Because that is only just for the purpose of some basic master data updates when relevant e-form has not updated the basic information which is visible on the master data under this CRF form. So please don't take this CRF on V3 portal for the purpose of change of any of the information which is going with incorporation document. Now, there are stricter KYC norms and validation for directors also. Every year, you have to go for revalidation of the D3 DIR3 KYC, and by way of a proactive approach, I think it is really vital to advise once a client that their personal mobile and email ID must be linked to their DIN and OTP verification. Now, a deactivation DIN definitely paralyze all the system. It may amount to section 184, disqualification of director. Here, I think it is to be understood that for the purpose of getting those respective OTPs for which date has been extended to file DI3 KYC under this era to 15th of October. But some of the time, we professional face a lot of issues and technical issues rather in getting OTPs whenever our stakeholder, our directors are residing somewhere outside India, like for example UK, Australia, or US. So you have to cope up with that and have to just find their sweet time so that after one or two options or maybe efforts, you can have that OTP workable for the purpose of updating your compliance actually. Now, there is a provision of mandatory dematerialization. Why? Because I'm touching upon these points before going to the technical aspects and technical discussion. Before we all must align our thought process where these basic things are required to go with a technical discussion on a incorporation of a structure or a structured company. Now, there are mandatory dematerialization of shares for specified private companies. Small companies, no doubt, are outside the preview of this, but yes, NSDL and CDSL as a custodian depositories give guidelines, and we provide those guidelines to our client. Please sit with your prospective promoter and company to update themselves about the modalities, what is required, how this will function actually, and what is the pros and cons of getting these shares in dematerialized form. Though it is now compulsory, there is no option with the stakeholder. Why? Because just to avoid those situations where government think that benami transactions may be the part of these share transfers or shareholdings, and as a beneficiary, it must be crystal and clear to the stakeholder, rather to the ministry, to have that clear cut transformation of those methods which were there in a physical mode when shares were freely transferable from one stakeholder to another stakeholder. The track record must be clear. The security must be there. The government must be visible. The technicalities which were there in a physical share transfer for a listed company or for a large companies, now it becomes smooth here actually, right? So dematerialization of shares has become the part and parcel of a process, of a corporate process, and maybe just after the incorporation you may need it actually. Now, CPACE was recently, introduced somewhere in September 2024, where faster voluntary striking of the companies was introduced. So why this? Before discussing the incorporation, because after the incorporation, many of the companies which may not, start their business, they have to opt these platform to make it defunct actually. Now, this is the data which has been taken from the Indian corporate, site actually, MC21 site, from the recent, newsletter. Whereas one may just find it that total active companies in India are about 19 lakhs 40,000. Now, out of these, this 19 lakh 40,000 number of closed companies number is really very surprising. And number of closed companies, including those companies which under the NDA government were shut down because either they were shell companies or they were not doing their business. So its number comes 9,65,000 around. So this is the number which is really very fascinating and very surprising, by because in a country where now government has opened up gates as a ease doing of business in India, these numbers really hit the corporate world, and one has to critically examine those numbers as well actually. My dear friends, these active companies which have been become the part of the incorporation process recently, in August 2025, you may look at the numbers where this integration of these structures have been just made easy by the Ministry of Corporate Affairs, describing these companies into a types of company like public, like listed and private companies. A lot of IPOs are coming, so August month has been very prominent for them. So all around 83 companies were just got listed actually over there actually. So these are the numbers which one has to see, and see that this month wise incorporation may vary in a particular year, and jurisdiction of ROC may also vary actually. Now, what I started, when I started my deliberation, you have to definitely go back to the physical era in 2006, when physical mode of memorandum, physical mode of article of association, and the process was state oriented. There was no as such platform, whereas you can just check the name, except the NIC services, which was ROC oriented. You had to visit to the ROC offices for the name check, and then there was no cross verification as far as trademark holder or trademark owner be protected actually in giving the name by the respective state ROCs actually. So it involved a lot of manual filing. It was having multiple forms. If you recall correctly, there were three prominent forms. Form 1, which was having articles and memorandum of association. Form number 32 for the appointment of first directors. And form number 18 just to show your first registered office. So combination of these three forms was to be submitted in physical form. That was the era actually till 2006, a very long era under the domain of Companies Act 1956. Then era which comes under the MC21 early e-filing phase from 2006 to 2015. INC 7 was the form which was inclusive e-form, but used to be taken care of in a PDF form. You please just download the form, fill the information whatever is needed, then go to the internet and then go to the MC21 site and file it with the other INC 8, INC 9, having all the information with all the attachments in physical form. You get the scanned copies of article and memorandum. You get it stamped, and you get it signed physically by the promoters, and then you attach the relevant documents with the INC 7 and then file it. So this was the era post MC21 system, and one can find this time frame from 2006 to 2015. Now, the next, which was spice based, it was 2016, and it was almost added to 2020, and it became a game changer where some web based rated forms form to information requirement by the ministry was simplified. So a simplified performer, what was earlier as a INC 7 was there, so INC 32 for the purpose of incorporating a document was there. The DIN were combined actually. Name reservation and incorporation into a single PDF e-form was made available for the stakeholders. So my dear friends, these three phases, I think one has to recall. Why? Because when you study these three phases, physical era, that was pre 2006, then post MC21 era from 2006 to 2015, then 2016 to 2020, you may find the efforts of the government, you can find the efforts of the ministry actually in getting the things smoother for the stakeholder, for the professionals, and we as a service providers. Now, when you approach 2020-21 ecosystem, post 2020-21 system, you will find a lot of changes, and these recent changes have just come to an end when web3 and spice plus forms were introduced in this ecosystem. Now a complete shift, a complete shift of paradigm. It is it's not a form, it's a information clutter which requires a lot of information you put in, and you have to be continuing on the web. Actually, there may be some sort of a pitfalls in adopting those technicalities by stakeholder or by professional, but it is simpler to examine, to cross examine, to take, to pop the data, maybe to retrieve the data from the earlier filled approved forms like DIN or maybe Spice A or Spice B. Actually, whenever you are getting your incorporation paper to other portals like GST portal, like for bank purposes, for PF purposes, for ESI purposes, I think you'll find a lot of similarities and similarity in terms of uniformity of data, which is shared among these ministries. Actually, there are overall three central ministries which are involved in this ecosystem, and other state government are involved in entire process in giving a single gateway to a stakeholder to incorporate a company. It means this has become you know uh, information centric rather than e-form centric. So e-form shift has been there positively in a way which has become information centric approach. So a lot of information will be required when you fill these documents. So this evaluation, I think as a student of Companies Act, we should keep in mind, and we should definitely deliberate sometime with our professional capacity, with professional stakeholders. Now, when you approach V3 portal, so there are some challenges, there are some strategies, but yes, some of the challenges which we are finding while navigating this MCA V3 portal when we incorporate a company. So let's, I think, first address those and try to understand what are those technicalities, what are those practical problems and issues and challenges which can be just overcome by designing our information in a way and standardizing, technically speaking, so that the process may become smooth. So most of the time, as a shareholder, as a stakeholder, you get pop-up that session has timeout. So whenever session timeouts and it give pop-ups, so I think this is web-based form, and that is why these timeout pop-ups are there. But it may lead to your data loss. So to avoid those, it is a strategy that use the save button every 5, 10, or 15 minutes slot. Advise your professional team who is working on the incorporation process to draft some lengthy content like your objects actually, so that those object clauses can be just typed or saved in a separate document, and you can just copy and paste in this particular web based form. Now there are certain alerts actually which says that DSC association and validation failed. So this is what you have to plan in advance whenever you are planning for the company incorporation. Please be sure that all the directors and all the shareholders whose digital signatures and the professional itself, it's you also as a professional, if they are being used on the MCA portal under the V3 portal. So most common point of failure of DSC association or de-association or validation failure maybe just maybe addressed by implementing a mandatory pre-filling checklist where you share it with the client, and you have the client's associate who confirm via email that yes, we have already registered our email with DSC association, and it has been now completed by all the signatories who are going to file the web-based V3 on the V3 portal, the Spice Plus A or Spice Plus B form actually. So please, I think you have to ensure before filing these incorporation related form. Now there may be problem of browser compatibility. This browser compatibility comes over when you have not read the requirement from the MCA 21 itself actually, which says that the portal works best on specific browsers like for example Chrome and Edge. Now when I was just looking at this Chrome, so I just found that some Internet Explorer 10 or above and Google Chrome 49 or above will definitely work. And try to just have it on your system. Always clear your browser cache and cookies before starting a major filing. And incorporation is a major filing, my dear friends. So you have to be very cautious in terms of these major filing. Now you have to maintain a dedicated browser profile for MCA work to avoid extension conflicts. Why? Because these conflicts will give you a lot of pain when you finally just log in and these pop-ups are coming on the system. So please, browser compatibility must be adhered to actually. Now there may be some vague messages also. Why? Because these are sometimes there is no fault on your side, there is no fault from the ministry's website or V3 portal, but there are vague error messages. Like for example, it gives system error occurs. This is something, a word sentence make your life very unstable, and you are nowhere actually how to answer it, how to address it. But I think as per our experience, take a screenshot if it is persisting, this problem is persisting, and it is again and again giving a pop-up of system error occurred. So take a screenshot, note the time when it was popped up, and take the SRN, and then step you are on. What was the step actually? Please raise a support ticket. And I think support ticket, as per my experience, is being addressed within 24 hours. Though I think before 24 hours also, it can be addressed. I think to your satisfaction. But sometimes just simply trying again after few you maybe minutes, few hours, I think this message may not be there as a vague message, my dear friends. So I think these things are there while navigating V3 portal when you are incorporating company. Now you have to be very clear. What is Spice Plus? What is Spice Plus? Let's have a overview. The division of this particular form under the V3 portal has been into two parts. Number one, the Spice Plus Part A and Spice Plus Part 2, and with other Agile Pro S, dominant forms which are legitimately and required mandatorily to be just associated with the main incorporation Spice Plus forms actually. Now more than a form, it is an integrated approach actually. These forms have an integrated approach wherein, when you recall, the concepts of ease doing of business in India, in West India, the government just wanted to have a single platform, whereas a lot of services may be given at a single platform. So it was, I think, settled over here. Though I cannot say settled. Why? Because a lot of other services are being, made as a part of the system. But definitely, if you look at the current Spice Plus, it covers almost 10 plus services actually. So part A, when you take part A, name reservation, it is now taken for two purposes. Number one, for reserving a name for new company, and for the purpose of changing the name of an existing company. So if you are just changing the name of existing company, just use a Spice A plus part A form actually. A lot of information is required in this particular A form, which we will definitely deliberate. Now part B, which is related to your core incorporation services. So when you take part B, it includes what is company incorporation, the DIN allotment, which can be made simultaneously as an integrated process with the INC 32, and up to three directors, they can have their DIN number simultaneously with the incorporation documents. There may be a PAN allotment, there may be a TAN allotment, which is mandatory, and you can have simultaneous approval under the part B as a core incorporate services. Now comes as a linked form. So when you have a cross part A and part B, then you will go to the Agile Pro S, that is INC 35, and you will have a lot of services over there. You can have GSTN, EPFO, ESIS, ESIC registration, professional tax. Some of the states have provided that, bank account opening, whereas you can have a choice when you open a bank account. Shop and establishment registration, state wise also you can have it actually. So these are the blueprints whenever you go to the Spice plus and part A and part B and other linked form when you are incorporating a company. So this is what the fundamental I have covered. Now let's analyze it actually. Whenever you are planning to have a name, let's have a strategy, my dear friends. Why? Because a lot of time we search on the MCA 21 system, but is it enough? It is not enough. I think you have to simultaneously search on the TM or trademark sites, IPS sites, whether same name is there or not. And you have to just create a search report for the client. Client is coming to you for a clear name. They don't want to infringe any of the existing trademark and all, but there may be some strategy, because whenever you have a strategy, you have to discuss it with your client actually. You have choices how to just pick the name, what name has been suggested by your client actually, and when you want to reserve it by way of a Spice Plus form under A actually category. So if you want to file together, or you want to file first actually, then an incorporation form. So there may be multiple permutation and combination of this thought process, and it may become a thought process when you discuss this with your client actually. So there may be 3, 4, 5 verticals when you have to choose the right strategy, how to apply your company name. So there may be scenario. So first scenario may be where client is adamant. Client says, oh, I am decisive, I am ready, I can take the risk, I am very much confident, convictionally I am the real owner of this name, this prefix can be used as a name, these are the supportive document, these are the trademark in favor of those names, so please go ahead with that. So if this is the client decisive and ready approach, I think you have no option as a professional but to file the name with the incorporation document. So file together. Though it is the fastest route, it reduces a lot of time, it reduces a lot of processing time if all the documents and details are finalized and filed in one go, including the name and the incorporation document. Second scenario may be where there may be uncertainty. about the multiple stakeholders, where a single stakeholder is not there, decisive approach is not there, one decision is not there as far as the name or finalization of the name is there. You are giving at least two names, where part A gives you option to give those two names as a option. So I think the strategy must be, and my recommendation must be, though it may be very personal to everybody, based on your client's choice, but please go for the reservation of the name first, actually. So when you reserve your name first, you save your client time, and at least you have 20 days to finalize other MOA and AOA clauses. Why? Because there are multiple stakeholders associated with the incorporation of that particular company. Like funding may be the subject matter of that company. So first reserve the name. Without losing the name, you may just go on with the 40 days or 60 days extension, actually. Now there may be other scenario. There may be complex name. There may be a trademark issue. So please don't take risk in one go. First, go for table A, apply the name first, reserve the name first, then go for the incorporation. It allows you to focus with your strong arguments solely on the name with the CRC. Why? Because it has already been approved without the complexity of the full application. So whenever you have a full application, there may be chances where this name, if you're not approved, so entire application will be collapsed, and you may be facing a lot of difficulties and impractical or practical scenario before your client. Actually, there may be some foreign promoters or subscribers in incorporating a subsidiary company or foreign subsidiary company. It is always advisable, please reserve the name first, then go for the incorporation. There may be another scenario, where sectoral or regulators approval needed, for example banking or insurance company. So it may not be possible for you to reserve the name and to file the incorporation document simultaneously. Why? Because there may be some time, whereas these nodal officers of the respective sectors regulator gives their consent to incorporate a company under that domain, maybe insurance or banking. So securing the name approval from Ministry of Corporate Affairs first, it strengthens the application before the regulator like RBI, SEBI, or IRDAI. So these may be scenario as per me, but there may be different verticals, there may be different permutation combinations, where these scenarios may spread into multiple choices, and your recommendation, your strategy to the stakeholder, to the client, must be strong enough, establishing some rationale, looking at the current scenario on V3 and the information which is required in one go on this MC21 system. I think this is what the part A strategy must be with you all and with me as well. My dear friends, this plus approach, which has given a lot of other documents creation, where we file a lot of information by way of a extendable, forms like EMOA or EAOA, has some challenges also. Why? Because it is electronically required, and these electronic memorandum articles are the part of Spice Plus document under Part B. Now these plus factors, which has to be understood by us, they are the linked forms, and they will be utilized later on in multiple service platforms, actually. Like for example, Agile Pro S, which we will be covering, it is related to directors and other office details and the registrations, actually. INC 9, for example, is a very very prominent declaration, which has now become the part of the online process. You have to declare, and the promoter has to declare that all the compliances of the companies in 2013 and other rules made there under with regard to incorporation process has been completed. So this is a declaration, actually, which is really important, and these all information will be used later on. For example, I have given example for the conversion data. So it will sync the data. The MC Tota 21 data will sync from these incorporation related information when you file URC1. When you look at the URC1, this is the relevant form when you convert some you know partnership firm or LLP into a company, then this URC1 will retrieve some data from already filed data with Spice Plus under Part B documents and Agile Pro S actually. So this is the internal system of MCA, and one can have a very deep understanding. It is what the internal understanding of the MCA 21 system, how the data is propelled actually from one source to another source, here to later on whenever you have some connected e-forms with regard to other processes and other compliances under the Provisional Companies Act. So this will be really important to punch those data information when you are filing these documents actually. With regard to EMOA and EAOA, there are some defined tables under the Schedule 1 of Companies Act 2013. But with regard to your customized EMOA or EAOA, what, as per my experience, when you have a very systematized or customized sort of a MOA or AOA, so I think my advice would be, at the time of incorporation, go by the process and have the AOA as per the format, because you cannot have many of the changes within the system with regard to that pre-structured AOA as per the Schedule 1 of Companies Act 2013. But later on, whenever you want to make it very robust, sort of a AOA or MOA, you can have the option to get it passed by way of a shareholder resolution, and then file relevant e form to just amend those EMOA or EAOA. So at the time of incorporation, don't be fussy actually to give that accurate and very robust type of a AOA running into 100 of pages actually. So avoid that situation actually, and discuss this with your client and stakeholder as well. My dear friends, now we will take a DIN identification number, which is very basic one. It is a very unique 8-digit number which is required by the individual by filing their KYC document, by filing DIR3 KYC form. We professional are the designated authorities to attest those DIR3 forms and the information, and for the purpose of applying those DIN numbers actually. The PAN is mandatory for the resident Indian national and who is citizen of India, but passport will be mandatory for the foreign national, despite of he has been residing in India for quite substantial time, say for example 182 days in India actually. Annual compliance you will have to cope up with by updating and filing DIR3 KYC, which is mandatory now every year. So deactivation of DIN may be resultant if you don't file in time those DIR3 KYC forms. This is something I just noticed that the first DIN was allotted to none other than our beloved late Mr. Ratan Tata. It was given, if you recall. So at the time, TCS was the custodian and the service provider when MC21 came in. I think that may be the reason why Ratan Tata was given 10, that is 1 actually. This is something, but first few other DIN may not be under the public domain. You may not get the details of those DIN. Now numbers are also hide in the V3 era, where you cannot have the 8 exact numbers from the system itself actually for a respective DIN number, except the government officials will have the access to that number, basically the DIN number. My dear friends, the DSC is necessary. Class 3 DSC will be there. This is a signature and is as good as the physical signature under the IT Act 2000. And the name in the DSC must be matching with your PAN, and character to character matching must be there. Otherwise, validation will fail actually. Whenever signatory, professional, subscriber, or any prospective director is just applying, they must associate their digital signature on the V3 portal by using their login own credential. And please mind it, and please understand that this is the single most common reason for filing failure actually. At the time of when you just reach to the final button to file it, there may be some pop up with regard to this disassociation. Now let's understand some other perspective when the some of the documents are to be notarized. Some of the documents are notarized internationally. Some of the documents are to be apostille, and some of the documents are consularized. Actually, my dear friends, as we all know that there may be a different purposes also for which these authentication of the legal document will be required and will be given a shape while filing your incorporation related document. Pertinently, in fact, for the foreign subsidiary and the foreign director, these documents must be either notarized and apostilled or consularized actually. So whenever there is an notarization, there may be apostilled also, or there may be consularization. So when we rightly understand that currently around 127 countries are the party to the Hague Apostille Convention, and this particular segment has been there. India has been the part of this Hague Convention till since 2005. As of 25, there are 127 members, and there are parties to the Hague Apostille Convention, my dear friends. So wherever this membership is there, including India, it means that public document, which is originating in any of these countries who are the members of Hague Apostille Convention, it means that public document originating in these member countries and bearing an apostille, that is authentication by the appropriate authority, they will be recognized as a authentic and valid document for the use in all other members countries. So whenever there is a incorporation document, some certificate of incorporation, maybe some constitutional document, some KYC document of the foreign directors, they must be notarized and apostilled. Apostille means in countries where this Hague Apostille Convention has been signed. India is a part of that. Wherever the countries are not the part of Hague Apostille Convention, then there may be a requirement to authenticate the document to be filed along with the incorporation document, which are duly consularized. It means after notarization, the authority will consularize it, and it will be a foreign ministry's level, and the seal of the same authority will be just put on that particular document before filing as an incorporation document. So notarized, which is authenticated by the foreign ministry and legalized by the Indian embassy. There may be an example. For example, if you file certain document for an Indian director, so Indian director's document shall be notarized. But whenever, for example, a UK parent company is there which is proposing to incorporate a subsidiary company in India, so UK parent company's document will be apostille. Why? Because UK is also the part of Hague Apostille Convention. But since UAE is not the part of the Hague Apostille Convention, so if any document which is coming from UAE or any native of UAE is becoming the director in Indian subsidiary, then that parent UAE company has to get its documents which are to be filed while incorporating a company in India. It will be well consularized actually. So let's understand the concept of these documents. Why? Because we tend to be confused when we come back to our client between these two, apostillization and consularization, apart from notarization. Now, recently, Ministry of Home Affairs, my dear friends, has introduced a security clearance. Earlier, it was for the aviation, companies, aviation service providers, whereas they used to apply online through eSahaj portal. So please visit eSahaj portal, and Ministry of Home Affairs scrutiny clearances is a really critical phase, and it is now mandatory regulatory step for foreign investment which is coming to India. And some sensitive sectors were there during COVID time also, whereas uncontrolled investment was there in India. by way of a corporate structure and by way of a incorporating corporate subsidiary in India actually. So the appointment of any foreign national as directors in certain Indian companies, it will be now restrictive in those sphere. It will serve as a vital safeguard for the national security and strategic interest. So Ministry of Home Affairs is the custodian ministry in line with and in coordination with the Ministry of Corporate Affairs to provide that clearance actually. Now, my dear friends, it is required for the proposals falling under the government route, especially in sectors like telecommunication, broadcasting, security agencies, and crucially for investment originating from countries which are sharing their land borders within India. So it may be Pakistan, Nepal, Bhutan, it may be China, it may be Bangladesh. So any director of that particular country which are sharing land with India have to first, before applying for it, have to first apply for security clearance with Ministry of Home Affairs on a portal which is called eSahaj portal. Now, you and me have the obligation to vet, to prepare, and to conduct a due diligence before we file any application before the Ministry of Home Affairs. It will undertake an exhaustive security vetting process internally and externally, and by way of their external counterpart, wherever the embassies and other commissioners are sitting in other countries. So they will have their own internal process to assess the antecedents and credibility of a foreigner who is a foreign entity and the individuals also who are proposing to become a director in Indian entity. It will mitigate the risk to national security. This is the core objective of the government actually. There may be a process timeline. So, due to interministerial consultation between the Ministry of Corporate Affairs and Ministry of Home Affairs, the detailed scrutiny will be conducted, and it will be time-taking process. Uh, Around, I think, as per my knowledge, around so far 1100 applications have been just processed and approved. Application should factor in significant lead time, typically ranging from 3 to 6 months time. Also, it may go so. Please accordingly consult your client, advise your client. Don't take any haphazard action in assuring and in promising your client that you will have a very clear and time bound approval from the Ministry of Home Affairs as far as security clearance is concerned. Further, Ministry of Home Affairs cleared the application, and it required a lot of documents which are to be kept in mind while applying on eSahaj portal, my dear friends. A comprehensive checklist has been provided on the portal itself, just for the benefit of your all. These are the documents to apply security clearance for the purpose of applying your DIN before applying your name and other incorporated documents. So your recent passport size photograph, it is a personal information, valid passport copy, duly notarized, permanent address proof, your utility bill, your national ID, if any, your present address proof, if it is different than the another one, a scanned or digital signature, and your professional financial disclosure on the eSahaj portal. The portal will demand detailed list of current directorship, and that directorship the system is asking globally wherever this proposed director who is applying for the security clearance, that manager personal position director will have to give a global directorship in many corporates actually. In my case, many of the times the director who is wishing to become the part of Indian entity, sometime he's the director in more than 80 countries actually, more than 80 companies, spreading into more than maybe 50, 60, or 70 countries. So it would be a very, very lengthy documentation. So please advise your client accordingly, my dear friends. So there may be legal compliance disclosure about the person who is applying for security clearance. It has to declare disclosing any criminal history of his or her, any pending cases, information about any regulatory penalties which have been imposed globally and maybe some other foreign country. So since last 5 years, whether these cases have been closed or not, right? So whenever you are handling these clearances may take a lot of delays, a lot of rejections also. Why? Because though data is not available right now, but the thing is, the lot of rejections have been made by the Ministry of Home Affairs while scrutinizing these applications of stakeholders. There may be track which is not as per the Ministry of Home Affairs guidelines internally. Actually, my dear friends, whenever you are tracking, so track diligently on the eSahaj portal your development, what is going on, how the application is being processed, what is the pendency, is there any requirement for the ministry side asking certain other options. If you are getting some impression that application is being delayed, so you have option to file your sort of a application with the ministry itself that yes, the application is being delayed and delayed beyond a reasonable time. Take those proactive communication with your client also. You can use grievance mechanism which is provided within the eSahaj portal, and you can raise your voice against that grievance actually. Now, if clearance is rejected, what you have to do? Please understand the reason. What is the reason? Analyze the reason. What is the reason of rejection actually? Please rectify, and you can reapply also if it is within your domain, it is within your professional expertise. You have the custody of all those documents. Otherwise, if it is related to some sort of a criminal action or maybe criminal sort of a background of the promoter of or a director, then I think you have to take a legal counsel to appeal. There is an appeal process also. Ministry of Home Affairs has provided, my dear friends. This appealing mechanism before the Ministry of Home Affairs, when it reject, there may be some points of advice. Uh, Please collect the core documents to substantiate your reply actually. Whenever there is a requirement of correction of some document or validation of some information which you have already provided, so please do that actually. There may be reason sometimes that you have not clarified in detail, so a detailed clarification has to be given by the Ministry of Home Affairs sought this clarification. Statement of reasons why this document is legitimate, and Ministry of Home Affairs should consider it as a legitimate document in supporting of this clearance actually. So you have to give those. So whenever Ministry of Home Affairs approval is required, there may be some other points that this is prerequisite. It's not post facto. It means that before applying the DIN number, you have to apply for this clearance actually from the Ministry of Home Affairs, my dear friends. There may be variable turnaround times. For example, application processing can take anywhere from few weeks to few months time, and national interest is prominent, so it will definitely take time, my dear friends. So I wanted to give more thrust on this Ministry of Home Affairs application, and then processing by the Ministry of Home Affairs, then just tracking my application till it is approved or rejected, my dear friends. There may be some key difference between some of the terminology which I have already covered actually, so I am skipping this slide, my dear friends. Now, as far as professional approach is concerned, there may be some important case laws which you must understand when you are proposing to incorporate a company in India. So these important cases now have become part and parcel of our practice, and these judicial precedents matter in every case of incorporation, my dear friends. Be it interpretation of law, be it guidance force, wherever gray area is there while incorporating a company, where there is a understanding of substantiate duties of proposed promoter or director. So this will mitigate your risk when you are just incorporating a company. So there are There are many cases, including some key judicial precedents. It may be number one, with regard to Posh Exports Private Limited versus the Registrar of Companies. Very important case. So this defines that and highlights also that procedural missteps at the time of incorporation can lead to scrutiny and possible remedial measures, but confirm the primacy of proper registration of compliances. So it definitely highlights that part of procedural lapse which may or which may not happen at the time of incorporation of a company as a possible remedial measure whenever the judicial system has to just vet it post incorporation of a company. In Kandoli Tea Company Limited, the Calcutta High Court clarified that even where all the shareholders were held by one person, for example, all the shares were held by one person, the company was a separate legal entity from the shareholders' point of view and emphasizing the procedural compliance in company law. There may be definition of promoters fiduciary duties, my dear friends, where in one of the case the principle was the promoters stand in a fiduciary relationship with the company you promote. They must make full and fair disclosure of every and each information which is required to be disclosed in any personal wisdom and interest with a transparent approach and with the company also. Which means the ministry has all the right, apart from giving security clearance, the Ministry of Company Affairs, to have that clarity as far as the data and the information which is being shared by way of this Spice Plus form. Now they cannot make secret profits at the time of post company incorporation or maybe during the time of incorporation. So whenever, for example, whenever a promoter is selling an asset to the newly formed or incorporated company, my role as a professional would be to just ensure transparency. I will insist on a registered valuer report to support the transaction. Why? Because promoter asset is being taken care of by the new company, by the new formed company. Now, this must be disclosed in the incorporation document or through appropriate board authorized resolution post incorporation also. So those interconnection in the post corporate action must be adhered to by us, and we will definitely look into that post incorporation process only. Now this process, the company minority shareholders interest is saved actually, maybe from any future allegation or dispute. Now, lifting of corporate veil, many of the cases have come up, including Delhi Development Authority versus Keeper Construction Company. So before studying that incorporation process with your client, one has to oversee these typicalities and technicalities while just advising our client to incorporate a company actually. Now, these are again, some of the leading judgments of KCP Infra Limited versus regional director, whereas Madras High Court has, upheld that the regional director power for ratification of KCP Infra after a complaint from KCP Limited holding that use of similar name infringed on the basis of trademark rights and constituted likely public confusion even after long existence. So what we have it that regional directors power are very limited in terms of procedural and other aspects. Whenever there is evidence of more proximity to the name application and there is a more strong trademark existing which was maybe avoided at the time of incorporation of a company, I think later action will dominate regional director action as well. Panchi Petha, for example, very prominent brand. Panchi Petha store was a Union of India. The Delhi High Court has, reaffirmed the concept that ratification application under Section 16(1)(b) it can be entertained if trademark ownership disputes exist. It narrowed the regional director power again and regional director inquiry scope to the similar confusion issues, not deep trademark adjudication. So court are having the powers, not the regional directors. So other judgment you have to just, and one has to definitely read before advising on incorporation of a company. So these are the principles which come from these lot of judgments. It means, please understand, a company name must not be identical or too similar to any existing company or trademark. When you read Rule 8 also of Section 4, you will definitely find the same connotation out of this statement. Central government can direct change within 3 months of notice. So if any proximity is fine, you have the option to change the name of that company. Acquiescence is a limited defense. Silence does not absolve even after dissolution. Under Section 248, registration is possible and reason director jurisdiction is procedural. The focus remains on statutory compliances, and it narrows down the decision making process of reason director. Whenever I am just making some appeal application before the reason director, if my name is rejected by the CRC. My dear friends, there may be name approval process where Rule 8 is important of Companies Incorporation Rule 2014. If name is identical or too similar, a registered trademark already, which is the subject matter of an application for the registration of a name, unless the consent or the no objection of the real owner is provided or obtained and attached with the name application. If the name is offensive to any section of the people, it is suggestive or patronage of any government or maybe the federal government, it is on the government or a constitutional authority. If you are using the name, like for example, national, union, federal, which are prohibited under Rule 8, it will require a lot of permissions from the central government, even if your company is a government company. Prohibit under the Emblem and Names Prevention of Improper Use Act 1950. So these are some peculiar points which we must keep in mind while applying our name. When you decode what is too similar, why you say too similar if you apply some name, what is the art, what is the science of these distinctiveness, the narrow distinctiveness, where I apply a name but this is rejected because of some or the other reason, giving a reference of it's too similar, then I have to go back to the authority. So CRC considers several factors internally. They have a SOP system. They have a synchronization between two systems. The name availability portal, that is imbibed under the MC21, and the trademark authority system. Wherever there are phonetic similarity, like for example Excel, you please spelling of the same, maybe just discuss with your client, EXCEXL, and you may also write it XCEL, is a phonetic similarity, rejected. It's right, CRC may reject it. There may be keyword similarity, like for example when you use common words like global but India, services, these are some keywords which are prohibited. You have to be testing your common words. If common person could be deceived into thinking one company is related to the other is the trademark owner actually. So here, before applying your name, please apply your mind, applying your wisdom, applying your search. You can search on MC21 system. Don't trust MC21 system only. Please search on trademark under the same classification or the others classification. Thereby, if rejected, you can substantiate your reply or your representation actually. Now, certain action will not work. Like for example, if you add or remove some plural versions or singular version, good versus goods, you are adding or removing punctuations, just, or you are giving some spaces between two words. You are just separating one word into two words but giving some space, but when you conversate that particular word, the phonetic meaning is the same. When you are changing the tense actually, for example go versus going, it will not serve, it will not give you a way to approve by the CRC your name actually. When you add generic word like India or enterprise, prohibited. So adding a unique, distinctive prefix is the most effective strategy. Sometimes, uh, I as as a consultant, as a professional, whenever I guide to the client, we first try to coin the word. We don't want to copy the word. We don't want, search the word. Some of the search may be of two types: generic or very specific. Generic is something which has been taken from some Google source actually. Specific one maybe some, coin, or maybe some evolved words which has been conceived by the promoter itself. And then again, the trademark which I am holding, or my promoter are holding, or maybe my some parent company is holding, that is something which dominates your name application, and CRC does not have any objection in giving those names actually. So this is something you have to understand. Now these are common grounds. Let's understand the common grounds of name rejection. There may be vague objects, there may be trademark conflict. There may be phonetic similarity. There may be lack of distinctiveness. There may be regulated words which are prohibited as such. There may be misleading geographical references. For example, you are using Himalaya water, but you are, or your company will just serve in somewhere in Chennai. So that is something I think CRC or the single node authority now, which is the single authority to approve names, has to taken care of. Now, there is a appeal procedure when a name is rejected. So, if you have that good, you have that professional dominance, if you can substantiate your name application, if rejected by CRC, please apply. Please apply and appeal before the appropriate authority. But first option would be you resubmit your first recourse. You resubmit within 15 days, whatever the time has been given to you. Resubmit your name if you want to reapply, if you want to resubstantiate, if you want to add on certain other documents to substantiate the application, please do that. You may file a fresh application with a clean slate if resubmission fails. And if you are not doing it, name has been rejected, go to regional director, challenge the action, the rejection, and then by filing your RD1 within 60 days, get processed your appeal before the regional director office, though it is time taking process. But if your application is based on substantiated document, I think your appeal must be clear and your name must be approved. Otherwise, the regional director, if they also reject, then the only approach is to approach the uh, courts actually, Indian courts, to have your name. My dear friends, these are some strong justification for resubmission. Uh, you have to attach a justification letter which should narrate everything about the name, differentiate business activity. You have to give your scale, your target audience, your jurisdiction wherein you want to just have your business. You have to provide search report, whatever you have done, encourage uniqueness to your client. Prefix method must work. For example, if you are using global, you use Shanti Global, there may be some sense actually. Digital identity check, you have to have maybe some sort of a domains in your name, .com, .in, .org, whatever. It will definitely add on your proximity to name substantiation, my dear friends. Now, my dear friends, we comes to the part B, the application. Let's have a deep dive. Though this is the heat of the incorporation process, but it provides a lot of information. It may require capital structure. It may provide registration, registered office. It may require subscriber details, director details. Ready with that data, who will sign digitally actually. Stamp duty, which is state oriented. Be ready with the attachments, and then professional declaration by the professional who is certifying the application. Now, when you look at the capital structure, the predominance discussion with the client, decide about the size of the capital, authorized capital, what would be the subscribed capital, nominal capital, but you have to discuss with the client, because in many of the instances what we have seen, that many of the time client may not decide about the maybe capital, and unreasonable they apply, which may affect your capital fees, which is chargeable at the time of filing your spice plus b form. So there may be common errors, some mismatch may be there under number of shares or capital. Please look at that, take the printout, scrutinize the document, where minimum capital is there. So bare minimum capital is rupees 2. In fact, rupees 1 share as subscribed by both the, if two subscriber there, you can have it, but just put some standard capital so that you can face some preliminary expenses also actually. uh, don't be trapped by zero fee, which is available only up to the nominal capital of 50 lakhs, 15 lakhs, that is 15 lakhs authorized capital. So advise your client accordingly, my dear friends. Now, registered office may be applied or may not be applied. So you have two options at the time of incorporation. If you're not going to apply your registered office, so within 30 days you have to apply. So the documents which are to be attached with your this application to show that registered office will be situated at such and such place, the documents, the utility bill which must be attached, duly notarized, apostilled, or consurized actually, it must be attached not older than 2 months. So I always ask my client to arrange at least 1 month older. Why? Because a lot of processing time, a lot of discussion time passes through, and we may skip that timelines of 2 months older. And based on that particular document, many of the times we have seen rejections actually, or we have seen resubmissions also. So these things are really required at the time of applying your name. Some address proof which are there as a gas bill, electricity bill, or telephone bill, if predominantly are government bill, I think it serves the purpose. There may be NOCs. NOCs means from the real owner of the property, who owns it actually. If you are the owner, then please provide your property bills. If you are not owner, you are a tenant or lessee, so provide that NOC from the main owner. If you have some option to provide some NOC from the main owner, and if owner has given you NOC to provide further his or her premises, the registered office, provide that linkage document with the NOC itself actually, my dear friends. You have to provide the office photograph having longitude, latitude. Please have it actually, and attach it with the part B for showing registered office as a registered office requirement. So these are the tips actually to apply your part B detail with regard to the registered office. Now, come to EMOA. What we have, elaborated that whenever you are punching EMOA, you have certain objective which are similar to your name and your HSN number and other, sub categories. But EMOA may have certain challenges with regard to providing your exclusive number of main objects which may not be covered here. So you have to design these memorandum, design these objective in a very meticulous, very articulated way. And when you have the format, the template has been used in the system of EMOA. This EMOA are based on the standard templates as per the Schedule 1 of the Act. Now, this object clause, most critical part is defining the company's legal capacity. Acts which are beyond objects are ultra virus. Please keep in mind. So don't insert any object which are ultra virus of the act itself actually. So beyond the powers actually. Ensure the main objects reflect the immediate businesses, and the company will conduct its business in that peripheral only. My dear friends, like MOA's article association also. While the template also provide the EMAOA template provides customized articles. You may have not a lot of options to modify it. uh, Delete clauses are not there. Many of the articles where not necessary, you have to give certain articles, you have to provide, but you are not able to provide. So my idea is just to document it by way of a post incorporation process, post corporate action process by way of a EGM, I think. So don't trust upon a lot of changes in EMOA or EAOA. My dear friends, some entrenchment provisions at the time of incorporation may be there, where you have to protect one class of shareholders, and this is the time when you can insert. The system asks you whether entrenchment provisions are there. You have to say yes or no accordingly, my dear friends. Now, there are certain final checks and balances before you upload the final form, and you have to check validation button. Throughout the system, you have to save your data which you have farmed included in the system itself. So these syntax error, if validation errors occurs, so these may be some of the mandatory fields which have not been filled actually. So these omissions may take you to that validation error. So check it actually. System itself will take you to that particular column where you have skipped something actually. So this pre-scrutiny will give you a crucial server side. Think of other side where you can check whether the MCA portal validates data against its database. For example, DIN status will have pan validity with it actually. Right? What DSC also have, if it is already registered, then it will give pop-up actually. Review your PDF, read it PDF, associate your DSC, save the copy, and then be affirmed that I am here to now file it actually. My dear friends, there is an integrated web. Now the other part, the system will take you to Agile Pro S. This will give you, and this will take you to many other you know uh, services actually, including application for goods and services tax, professional tax, registration and opening of EPFO, ESIC, and other bank account related services. Now, my dear friends, like professional tax and bank account, uh, professional tax in, like for example, in many of the states, like for example in Maharashtra, Karnataka, and Delhi. So these state specific mandates that yes, you have to apply for the professional tax also. There may be a form which handles registration for the company as an employer or for itself as a PTRC and PTEC under the professional tax domain. Shop and establishment registration, which provides, under the labor domain and governed by state-specific laws. So Agile Pro S has integrated this approach also with certain states to provide this registration at the time of incorporation. The purpose of this particular registration is to regularize the conditions of work, working hours, holidays, and other rights of employees in commercial establishment. You may open a bank account, but after the bank account opening, you have to revisit your bank post incorporation for the verification of your physical EYC, KYC, and physical verifications. Professional role, you need to check if the state where the registered office is located has been integrated with Agile Pro S. If not, then advise the client that this registration must be obtained separately from the state's labor department post incorporation. So we are talking about shop and establishment registration. The advice to the client would be proactively follow up with the bank branch after a few days, as the bank will still require in-person verification and other KYC formalities to activate the account. So, my dear friends, this is something which has to be taken care of as a most crucial advisory as a professional, my dear friends. Now, there are practical implications of Agile Pro S. These are that there is a no opt out policy. It reiterates to clients that these registrations are mandatory, bundle service integrated with incorporation. But may I advise you to examine GST registration simultaneously on case to case basis. You have to be immediately after the incorporation, you will be thrown to immediate compliance burden under GST, EPFO, and ECIC from day one, which will require a lot of proactive filing management. Post incorporation hand holding, post filing of a few forms, returns will definitely and immediately start when you get an incorporation certificate. But at the same time, it reduces a lot of risk. It mitigates the risk. It provides detailed post incorporation compliance calendar at a time, and it saves you from a lot of skipping at the time of incorporation process, my dear friends. Now, my dear friends, may I just share with you some do and don'ts, while incorporating a company as a practitioner, as a professional. So, do conduct comprehensive name, trademark, and domain name searches upfront. Do use a standardized checklist to collect all documents and information from clients before starting the processes. It may be customized by your office. Do verify the live status of DINs and validity of DSC for all signatories on the day of filing. Do advise clients in writing via email about the immediate compliance requirement arising from Agile Pro to create a record. Do keep the clients informed with regular proactive updates at every stage. Be in touch with the clients, my dear friends. Do use the MC help desk and raise ticket for technical issues, meticulously decoding the ticket number, etc. Now, can we discuss don'ts during the time of incorporation? Don't promise unrealistic timelines with your client. Always factor in potential risk and potential time in handling the portal issues or CRC queries. Don't draft vague one line object clauses. Be specific and well defined and detailed objects. Don't use an address without a recent utility bill and a clear, correct, worded NOCs, legible copy. Don't forget to ensure every signatory has associated their DSC on the V3 portal actually. Don't treat the auto-generated INC9 lightly, my dear friends. It is to be given by the promoters, and it's a declaration which is having a legal binding effect, my dear friends. Don't submit scanned documents with poor resolution, shadow, or cropped adjective. Why? Because it becomes a final copy on the portal actually. When your client is onboarded, the best practice is to have the engagement letter for the incorporation process. What is the objective? Share the checklist. Now have the kickoff call with the client at least for half an hour with their counterpart, their associate, their consultants. This kickoff call will deliberate a lot of issues with regard to their expectation about the mandatory timelines and mandatory regulatory and registration processes. This will definitely give you a way ahead what other professions are doing. A data verification process. So between the filing and getting the data, and before filing, send a final data sheet with all key information, names, address, capital, shareholding, and all other attachments to the client and get the client signed copies and signed confirmation. This will create a audit trail for you, my dear friends. When you are handling some resubmission professionally, may I advise you that may I just deliberate this issue with you very diligently, that you have to just analyze the query, what has been raised. You have to resubmit professionally. What is the root cause of this resubmission? How can you rectify promptly? How can you communicate transparently with the authority? And whatever best you can just provide to the ministry in getting your application as approved. My dear friends, these are post incorporation compliances, though it is directly or indirectly related with the your incorporation. So first 30 days are crucial with regard to taking care of a lot of agenda item your respective first board meeting, including you have to note the certificate of incorporation in the first board meeting to be held in 30 days time. You have to authorize the opening of a bank account if it has been approved. under Spice Plus Agile Pro S form. You have to appoint the first auditor. You have to take on record the disclosure of interest from the director, and you have to authorize the issue of share certificates. Actually, you have to appoint the first auditor. Next is month from the date of incorporation are also critical, and you will have to issue share certificates after receiving the subscription money. You have to file INC 20 for the purpose of commencement of business, so that you can borrow money without filing the with the filing of this INC 20A form. You have to maintain that lot of record, internal record, including minutes and statutory registered, my dear friends. Now there may be some private limited company, rated public limited, every type of companies. We may just fastly go through these. Though as an entrepreneur, my first high number is as a private company. Why? Because a lot of stakeholder examine and find private structure as a core structure to start with as a corporate entity. And my dear friends, this approach is really very simple whenever you are incorporate a company. And a private limited company will have two members, more than two members, but not more than 200 members would be there. Minimum two members, 15 members, maybe maximum. It will end with the private limited. Capital structure, there is no minimum capital structure has been there. uh, for the standard path and for advisory point, it's ideal for startup, family business, small businesses, closely held companies. So this structure can be just advised to the client. Actually, you have to explain to the client the concept of the will of incorporation, limited liability partnership as well to the clients. Now there may be a requirement of public limited company. Many of the times clients requires it. You have to just tell them the threshold for great scalability. If the client is finding it that the company has to be a public one, they are going for IPO, for example, or SME IPO, there may be certain threshold limit as a private company. uh, we all know that minimum 7 members, no maximum limit for the members. Directors 3 must end with limited capital. There is no minimum paid up capital requirement. And suitable for large class or large scale of business houses who are planning for significant expansion, or eventual IPO, maybe a big manufacturing unit or trading unit, and which are clearly explain the significantly higher compliance burden in comparison to private company. So you have to share it with your future clients, my dear friends. One person company, my dear friends, as we all know, company which has only one person as a member may become OPC. It combines the limited liability of a company with the simplicity of a sole proprietorship. The member must nominate another individual who will become the member in case of the original member's death or incapacity, and you have to file a declaration of that nominee with this particular spice form. Only one member may become, who is the natural one. Indian citizen must be there. Who is resident in India can become the member of OBC. Nominee mandatory hai. Different person must be appointed as a nominee. Their consent in form number INC3 is mandatory, actually, right? Advisory, explain the rules and around compulsory who are working under proprietorship business can be advised to have a OPC sort of a business, which can later on, if business accelerate or business increases, it can be converted to a private limited company, my dear friends. Now these are charitable and non-profit objective companies. Section 8 companies, you have to have a prior permission. There is a license to do good charitable business. The name must include words like foundation, forums, association, chambers, confederation, etc. But it means, apart from trust and society, this section 8 is a corporate posture for a company having charitable objects. So minimum 2 for a private limited structure, minimum 7 if that company is being incorporated as a public company. This license from the central government, now power has been delegated to registrar of companies to have the license of section 8 company, which is a charitable company. And this prerequisite for incorporation license is prerequisite for having the charitable objective for the charitable company. Now there is a two-step process for section 8 company. First, you have to apply for license and then incorporate the company later. You have to obtain a name approval, apply that part A to receive a suitable name, apply for license. For example, you file e-form, relevant e-form is INC 12. This is a separate application to be made before ROC, and there are key information which has to be given to the registrar of companies. Please draft MOA, which should not in any way distribute profit or dividend. Actually, the objective must be charitable in nature for the promotion of art, science, and culture. AOA must be defined and structured in a way which gives you an impression that it is a charitable company. A declaration from a practicing professional like us in INC 14 that all the compliances have been completed. A detailed 3 years financial projections with regard to your charitable objective must be attached with this particular form while applying for the license from the registrar of companies. Now incorporate this company having this license in Spice Part B. So after you have the license granted by the ROC, file the incorporation form quoting the UN number. Now, as a compliance and governance key, a lot of issue crop up while incorporating a Section 8 company, my dear friends. The compliance burden is high, no doubt, especially concerning the utilization of funds and related party transactions. Advise on the importance of obtaining registration under Section 12A and 80G simultaneously to your client under the Income Tax Act to gain tax exemption from the company's income and provide the benefit to your donors and all. The license can be revoked at any time by the ROC if it finds that the rights given under the an obligation under the license have been infringed actually. So please be careful while incorporating a Section 8 company under the Provision of the Companies Act 2013. Now, next type of company is producer company, my dear friends. Concept is very old. 2002 has given that gateway from where producer company started incorporated, but in many years rules governing producer company incorporation under the Companies Act 2013 was dominated by old Companies Act 1956 only, but recently just the rules have been just framed to incorporated producer company. The rooted whenever a agriculturist and this is a hybrid sort of a structure which combines aspect of cooperative society and a corporate culture as a company. So body corporate which is to be registered as a producer company with the object of activities related to and specified under Section 387C of the Act. If you read it very closely, Section 378C will provide you a lot of objective which are related to agriculture. Now, core objects will include activities which relates to production, harvesting, procurement, grading, pooling, handling, marketing, selling, or export of the primary products or produce of the agriculture, which are coming from the members of this producer company. There are key requirements. Eligibility, it must be primary producers. So all the primary producers only can become the promoter of the company. Persons who are engaged in activities related to primary producers may become the promoters in this company. Minimum 5 director must be there and must end with the word producer company limited. At least 10 members, 10 or more individual, each of them being a producer. So each member must be a producer. 10 members are required to produce a producer company to just incorporate a producer company. Even if individuals are not there, the 2 or more producer institutions or a combination of 10 or more individuals and producer institutions may incorporate this producer company. Now, incorporation process of a you know structure, nidhi structure is also important, which I'm just for the sake of brevity of time, I'm skipping. Government company, yes, as per definition, government company may be called a company if not less than 51% of the paid up share capital is held by central government, state government, or by both actually. So wherever shareholders, the promoters are there as a government company, so they become just government company. The key requirements are some sort of a nodal officers approval, nodal ministries approval. Promoters can become as a subscriber to the MOA and AOA. The person acting on behalf of the ministry, or the person or on behalf of the president of India, or the state governor can become the member of that. So there is a ministerial approval also. So prerequisite is approval from the concerned administrative ministry. For example, Ministry of Power for a power sector company is essential before filing of the incorporation. The first auditor and subsequent auditor are appointed by the CAG of India. So government company, in fact, I got a chance to incorporate government company in my very first phase of practice for the Uttarakhand government. It was it was a company limited by guarantee actually. So be specific, just consult and consult with the authority. Why? Because here the stakeholders is high. Why? Because bureaucracy will just discuss all the modalities with regard to the incorporation company with you. So be ready with that. This is something very typical. So before that, have idea, a lot of reading, then lot of discussions actually will help. Then you will be able to just incorporate this government company, my dear friends. Now, foreign subsidiary, we tend to incorporate many of the subsidiaries, foreign subsidiaries in India. There may be a similar, things, but you have to have a lot of discussion with the foreign stakeholders, whether they are studying here, residing here or not, whether the documents are being notarized, consularized, or apostilled. What sort of document you are getting, how you are getting the clearance or security clearance from the respective Ministry of Home Affairs. So these are some regulatory advisories where you can have this foreign subsidiaries also. There is no as such difference, but yes, documentation wise, you have to be very cautious that each and every document, from the time of name approval till the time of name incorporation, maybe their basic document, fundamental document, trademark document, name approval related documents, their KYC document, directors related documents, shareholders, proposed shareholders related documents, subscribers related documents must be just notarized or apostilled in a country from where this parent company is just originating. So I think you have to be very clear about this foreign subsidiary company, my dear friends. My dear friends, some of the time we professionals are confused with regard to new company or a startup company. Some of the stakeholders, not professionals, they tend to just designate a new company as a startup company, though it's not so. A company may become a startup company, but once it's gets some sort of recognition from DPIIT. So there is an eligibility criteria for DPIIT recognition. So after incorporation of your private company or a private company or public company, whatever, a startup in India is officially recognized by the Department for Promotion of Industry and Internal Trade, that is DPIIT. So, based on specific criteria, the recognition is given, license is given to the respective company to act as startup company, so that they can have a lot of liberties with regard to exemptions under Income Tax Act, right? Some 10 years, tax holidays being provided. It must be a only private company. Their registered partnership firm or a limited liability partnership may be there. Their turnover cap has been kept as 100 crore, not more than that actually. There may be a innovative idea. So whenever you are advising your client who is proposing to have a sort of a startup, just discuss about trademark, copyrights, some if they are having sort of a very innovative idea, and you have intellectual property, discuss that intellectual property with them actually, with the key benefits of startups company actually. So you have to have an application to be made before DPIIT for the purpose of recognition as a startup company, my dear friends. Limited liability partnership, for the brevity of time, I'm just skipping, my dear friends. Registration process more or less takes the same mindset. When you have the name reservation by way of an LLP has to be there, then you have to form the LLP by way of filing incorporation, and by giving details of everything about the designated partner in Philip form. You can just have the the limited liability partnership agreement, which may be filed at the time of incorporation or maybe within 30 days in form number 3. So these are the limited liability partnership incorporation process which can be just taken care of. My dear friends, I just wanted to give 5 minutes more on this, then I will just conclude my PPT. This is what International Financial Services Central Authority IFSCA has for you. The gift city, which has propounded many of the fintech company in the gift city and the bath. So let's have the key highlights for incorporating company as a IFCA in gift city actually. So a lot of regulatory approvals are required when you say IFSCA. In financial terms, company has been incorporated. Simple incorporation, the companies at 2030 will not serve the purpose. So you have to finalize, you have to secure first office space in the special economic zone within the gift city, my dear friends. You have to have a lease agreement, you have to have a co-developer from any office premise from the developer or the co-developer. You have to apply for a provisional letter of allotment to confirm that the office space allocation has been made. This is mandatory, my dear friends, to apply before IFSCA. My dear friends, you have to choose a suitable business structure, commonly a company or a LLP for financial operations. My dear friends, you have to submit the necessary documents like MOA, AOA, board resolution, financial statements, and project report for the incorporation filings actually. You have to register within the Ministry of Corporate Affairs, what we have discussed so far, and then relevant SEZ authorities, that is IFSCE authorities, including filing form F, which is very prominent form describing many of the information with regard to your business and its perspective with supporting annexure. Mandatory inclusion of IFSC in the name of the company as a entry registration in gift city will give you a pathway as a entry to the IFCA. The under the companies at 2030, many of the provisions wherever you are just looking at, many exemptions have been given to that category of thing. So please, you can just have a great documentation with regard to that IFCA. But due to paucity of time, I'm not going to the documentation part, my dear friends. Now, Ministry of Corporate Affairs is the nodal agency to incorporate a company. IFCA, that is an international financial service provider, that is a central authority, is a primary regulator for licensing and supervising the financial services within the IFCA. All financial services activity must be approved by IFSCA authority. Then SEZ authority, which is special economic zone within the gift cities there, will provide you that approval from the development commissioner of SEZ to set up your unit within the gift city, my dear friends. So have your due diligence, have your business plan ready, lot of discussion with your prospective international client, take help. A lot of banks have already started establishing their base in gift city actually, and this is the next maybe UK, London market or Singapore market. It will open the gateway for a lot of capital which will be infused in manufacturing and real estate sector in India. So it's the next big boom as far as the incorporation process under this SEZ under gift city is there actually. So these are the detailed. Please Google it, go to the site, read a lot of things about IFCA, and then try to learn the process apart from normal process of incorporation company, how to have a incorporate body under SEZ in your gift city, my dear friends. My dear friends, I'm not just going through this subscription money or borrowing. This is after the incorporation process. So you have some limitation till the time you file your INC 20. So don't go for that. Many of the clients, many of the companies have done it actually, and they have to get it compounded, my dear friends. Please don't do that. Teach your client, advise your clients, just adhere to the provisions of the Companies Act. Don't do anything unreasonable, my dear friends. So this is for the exception for borrowing rules, which I'm just not going for the same. Thank you so much for your patience learning. Thank you so much.
Yes, sir. We have received some queries from the participants, and with your permission, we would like to seek your response to them.
Please.
So our first question is whether the declaration for non-acceptance of deposits and the of section 7 subsection 1C needs to be separately signed and submitted at the time of filing SPICE Part B, as these get generated in the e-forms.
Yes, you have to have it actually. Why? Because in many of the instances, the CRC has come back with a remark by way of a resubmission that you have to provide it. So, by way of this declaration, you are just adhering that you are not becoming a public deposit acceptance company. Why? Because the domain for other class of NBFC is there. You are not a deposit acceptance company. You have to give the declaration in the format provided over there.
Also, next question is for conversion of unregistered partnership into a private limited company. Can the proposed company adopt table F for AOA, or is it required to include any specific article providing for taking over the assets and liabilities of the firm?
You can take the table F, no doubt about it, and many of the options therein may also be changed actually. But when you are converting a unincorporated body like partnership firm, you are converting into a company by filing URC and all. So a lot of data which is predominantly is there, which would be just be captured in the new form, will give you sort of comfort. But as far as your object clause or your articles are there, it would be more defined actually. So I may compare these two entities where originally I incorporate a company, but second option is where I convert a company. So when I convert a company from non-incorporated to incorporated, I think I have to be more cautious by giving more robust articles and robust objects. Why? Because wherein one of the objects may be that you are taking care of that unincorporated body converted to a converted body. Why? Because for future reference, you have to quote it actually. So apart from the standard format, whatever has been given within the system of a spice plus part B, you have to add on those. Nobody just restrict you actually. You have to add on. Over to you.
So one more question is that a foreign company is planning to establish a subsidiary in India. Can the subscriber to MOA be a registered Indian on behalf of foreign company if he is duly authorized by the power of attorney and the board resolution? And so also whether a physical copy of MOA, AOA of such newly incorporated company needs to be apostolized.
See, whenever you are just taking a person from origination, actually, so you have to have a parent company clear cut authorization in his or her favor, actually, right? So this is by way of a board resolution of a parent company, which is duly notarized and apostilled or conspirized, actually. So whenever you are taking the EMOA or EAOA, this is there actually need not to be a postal. Why? Because e-verification of the digital signature of the subscriber is there. So if you are taking the recourse to the physical one, yes, it has to be a postilled and notarized.
Also, another question is whether a company, Section 8 company limited by share, be converted to Section 8 company limited by guarantee without issuing share. Is there any condition that need to be satisfied for such a conversion?
I have not seen it actually, personally speaking. So, and there is no prohibition as such in the Companies Act also, right? But I think subject to the approval of, maybe ROC or ROC has the power. The correct version maybe yes, if all the shareholders are just surrendering their share capital. So I doubt that having a share capital may be converted to a having the this I may
Good.
not be very sure actually about it. So this question may be just kept for future reference. I may just give you after referring it to. Why? Because I've not come across this situation so far.
Okay, sir. Noted, sir. So for overseas subscriber and director, are the document required to be notarized and apostille for the incorporation of a company? It is absolute.
There may be two
Yes.
situation where that outside director, foreign director residing in India, for example, for substantial time. So how you will get his or her signature apostilled or notarized in a country of his native? For example, one Australian who is having the passport is residing in India, and while he is in residing in India, that is Australian parent company authorized him to incorporate a company in India. So his document may not be a apostille or notarized in Australia actually. So someone in India, maybe professional, like for example, if the original are presented before me based on his residency status, I may just certify the document or maybe notarize over here in India. Over to you.
For the company secretary, sir, how to work on the name requirement of the client, as the client at the times is very specific about the name, how to find out a middle way to proceed with the incorporation of business.
I think the starting way, middle way, or the end way is just research, research, and research. You have to, like for example, I just give you a name. This is a prefix, this is a suffix, and now incorporate a company for me. Oh, I go back to MC21 systems. No, go to your Google search, MC21 search, and trademark search. If you are really clear that nothing is just infringing, then advise bluntly, maybe within, I take for example 2 hours to search. For example, sometime I have to search for a week time. There's a lot of searches there, and there may be some infringement where some foreign companies having some trademark, but I'm finding it difficult in getting that name in India. Why? Because with the same name some other companies there. So first I have to take the legal recourse against that company. The look, I'm having the trademark, I'm coming to India now, this will restrict me, give me that number, give me that name. The other case will just go on simultaneously, but I have to incorporate my company with the trademark I'm having internationally. So these are few combination, a permutation combination which we have to look at while examining each and every name application. So my friend has to understand that each and every name application cannot be at par as far as understanding and approval of the same is concerned on the MC portal. So it's a research, it's a truly research which you make on the different portals actually.
So is there any validity of apostille documents or some expiry that after that period you cannot use these documents?
In fact, I have done it. Like for example, I don't prefer to use those documents if they are not used within 60 days from the date of notarization. For example, there is no prohibition as such. There may be some other thought process of other professional, but I simply advise my client not to use more than 60 days notarize or post papers. Do it again, get it again, so that a fresh papers can be just there actually. See, there may be some reason where utility bill has been given the authenticity of 2 months period. So the 60 days period is there, so you have to be in terms of interpretation, you have to be liberal, you have to be interpreting judiciously, you have to be very clear in terms of getting those paper. Though nothing prohibited in the Companies Act, uh, wherein it is providing that not more than 60 days time authorized document can be used or cannot be used actually. So it is based on your advice. I personally don't advise my client to use 60 days or more than 60 days of documents which are notarized or consulized or apostille. Over to
Also,
you.
a company changed its name to new name and CRC issued the fresh certificate of incorporation. Now the same company wants its old name, but the CRC is rejecting the application, mentioning Rule 8A1E and saying it to apply after 3 years, which was not the condition previously. So in that case, what to do, sir?
Just fight. Just
Just we
fight
have
for this name. Why? Because you have to substantiate this name application why you require it. I think for the sake of just name, you are getting it, or you are having some good business plan under the same brand, under the same name. If you can prove it, you can fight it.
And so someone is asking for suggestions from for publication for incorporation and related matters. So can you suggest some publications, sir?
Oh, in fact, I think uh, for incorporation purposes, I tend to stay on MC21 site and law actually, procedure why. But when you look at ICSI publication, a lot of publication of ICSI, I'm not, recalling the name of publication, but yes, it is there. So please be there within the ICSI publication. A lot of short publications are there. Charter Secretary is one of the great publication which provides a lot of information with regard to amendments. Now I think this WhatsApp channel, I think of ICSI, it is also providing a lot of information with regard to those clarification which are coming from a lot of authorities. As far as Gift City is concerned, which I'm just very excited for my professional friends. I think please study that Gift City website and IFSCA website to have a deep knowledge of Gift City and related matters, my dear friends.
Thank you so much, sir, for sharing valuable knowledge and practical perspective on the various aspects of the company formation under the Companies Act 2013. Your expert insights have certainly enriched our understanding of the subject. And I would also like to sincerely thanks to all participants for their active involvement and thoughtful questions and enthusiastic participation. Thank you so much.
Thank you so much. In fact, though I just tried that yes, this topic should not remain as journal. Why? Because every one of us can incorporate a company very easily. But what are the points which you should keep in mind? What are the points, what critical points we avoid actually? So I think you have to be more cautious. I can just advise my fresh company secretaries to discuss openly with their seniors what modalities they should adopt, what help they can help from their seniors as well. I think that is a thumb rule which I learned for my seniors within the professional body of ICSI. Thank you so much.
Thank you so much, sir. Thank
Thank
you.
you.